It's a topic that comes up all the time that I just always, just as a risk management tool, like to remind all of our members of, and that is that realtors need to be very careful not to engage in the unauthorized practice of law. Today we're going to talk a little bit just about some of the specific rules, and you need to keep in mind that the real estate rules basically prohibit you from engaging in the unauthorized practice of law.
Now, Gabe, one simple way I want to state this is that realtors be the realtors,
Yep.
right? Be the realtor. Maybe another way of putting it is stay in your own lane. Do what you do. Do what you know how to do. Stay in your own lane. Don't go outside of that lane. Be very careful.
And if you actually look at the specific rule, it's very clear what kinds of things are permissible. For example, Iowa Administrative Code Chapter 193 says that upon written request of a buyer, a seller, a non-lawyer may select, prepare, and complete certain form documents for use incident to a residential real estate transaction of 4 units or less. It goes on to say that such documents shall be limited to offers to purchase or purchase agreements, provided, very important, provided the parties are given written notice that these are binding legal documents and competent legal advice should be sought before signing, groundwater hazard statements, and declaration of value forms. Again, that lays out the certain things that a non-lawyer can do in a residential real estate transaction.
But Gabe, the question is this. This is where the question comes up. What if you, as the realtor, are in a situation where your buyer, your seller, wants you to go outside of what those rules allow? Now, how do we handle that? What advice can we give the viewers on that?
Absolutely, and I think, George, that's the real question here, right? You know, we all know that there's been a time in a real estate transaction, right, where there's some question that comes up. And, you know, your client probably is paying you some kind of compensation for the transaction. And, you know, they tell you, look, I'm paying you a lot of money. It's really expensive for me to hire an attorney. I know you as a real estate professional see this all the time. You know, off the record, can you give me some advice on what I should do here? I don't want to call a lawyer.
And that's exactly right. And the realtors are going to be asked those questions, right? It's just part of the profession. Be careful how you answer those questions, or maybe you shouldn't answer those questions, because I will tell you this. That client, that buyer, that seller is going to remember what you told them. And it may come back that what you told them, off the record, if you will, was something which might be considered the unauthorized practice of law.
Absolutely. And what I think you need to keep in mind is what George already said, right? Just stay in your lane. I think the other words we can use is, you know, resist the temptation. Yeah. You know, people are going to ask you off the record, you know, I know you're not a lawyer. I know you can't give me legal advice, but what about this? Don't do it. Yeah. Don't give into that temptation, because the last thing you want is to be on the other side of a claim that you somehow put your client in a bad situation by giving them some kind of professional advice outside the scope of your license.
Gabe, you mentioned earlier things that the court rules allow
Yes.
realtors to do, right? Prepare documents. Now, let's talk a little bit about maybe some things that realtors may be tempted to do, may be asked to do by their clients, which might be considered, right, the practice of law.
Yeah. So I think one of the things, George, and we could probably go back and maybe we don't have very clear 100% all-encompassing answers for this, but addendums. That comes up all the time, right? For example, a realtor might use an addendum in a transaction to change, you know, amend the sales price. With an amendment, amend the sales price, or amend a deadline or something like that, right? They're preparing a form document. You know, that probably, in my opinion, isn't engaging in the unauthorized practice of law. You know, that's arguably just preparing a form document.
What if we go beyond the addendum? Let's say that there's a title issue.
Right.
Right? And it can only be cleared up by a title affidavit.
Yep. I would say 100% that in such a situation, a realtor has one thing that they should do in that situation is tell your client that is a legal question. I'm not your attorney. I'm giving you real estate services. I'm not providing you legal services, and you need to seek the advice of a competent attorney for advice on that matter.
Things such as preparation of deeds.
Yep. Absolutely something a realtor shouldn't be doing. That's something that in every situation you should be having a licensed lawyer handle.
You know, there's a case that I recall where a realtor was charged with unauthorized practice of law because that realtor prepared mortgages for clients.
Yeah. And just goes to show, I mean, those can be huge, huge issues of liability. You don't want to get into those situations. But keep in mind too, what the rule says is you can, prepare and complete form documents. In other words, forms that have already been approved, like IAR standard forms that have been approved by licensed attorneys and have been vetted. But if you go into those and start adding addendums to them and start changing key limitation of liability clauses or something like that, you could be putting yourself in a serious issue.
So if you take a little bit from this form and a little bit from that form, a little bit from that form, put your own form together, practice of law.
Practice of law, absolutely. Those are things that, again, you can only be using forms prepared by licensed lawyers that have been verified, that have been vetted. Otherwise, you're going to run into problems.
And Article 13 of the code specifically talks about the unauthorized practice of law. It doesn't say the realtor might or should, but says shall.
Absolutely.
Shall request counsel in those situations.
Absolutely. It's not just a good idea to have your clients talk to a lawyer. It's a requirement. When you become a realtor, you agree to be bound by the Code of Ethics, that very high professional set of standards, and make sure, resist the temptation. A client might not want to make that other call to a lawyer, but you need to recommend they do so to make sure you put them in the best position that they can be.
One other thing I want to bring to the viewer's attention is this, that the Iowa Supreme Court does have a commission on the unauthorized practice of law. And complaints can be filed with that commission and will be investigated. And as a member of the bar, on occasion, we will get notifications of people that have been charged with practicing law without a license and making us aware of that type of conduct that does go on.
Absolutely. Look, the Iowa Supreme Court in its decision in Bump versus District Court of Polk County has some great language about the practice of law. What the court there said is that the practice of law is generally understood as the doing or performing services in a court of justice in any matter depending therein throughout its various stages, but in a larger sense, right? In a larger sense includes legal advice and counsel and the preparation of instruments and contracts by which legal rights are secured.
So there's no one definite definition of the unauthorized practice of law, but those are guidances.
Absolutely not. And the court even in that case went on to say it's been pointed out that it's practically impossible, right? It's practically impossible to frame any comprehensive and satisfactory definition of what all constitutes the practice of law, which again goes to show you need to be very careful. You don't want to be the case that gets recorded and then gets published about a situation where a realtor violated these provisions.
Hey, Gabe, briefly here, you man the hotline. You get questions about this and other things all the time, right? Okay. Anything you want to share with us? Maybe some of the most common questions you've gotten that you want to share with the viewers?
Sure. For example, I'll get questions all the time that might relate to seller disclosure provisions of the Iowa Code. And I think what's very important for realtors to always keep in mind, right, is just by being a real estate licensee, by going through classes, by having a license, that generally speaking in residential real estate transactions where there's 1 to 4 dwelling units, that a seller is going to have to provide a seller disclosure in writing per the provisions of the code unless they meet an exemption, right? You know that. That's general knowledge. You're aware of that. But if you get into a situation where a client says, hey, I see the code, I see all these exemptions, have I met my obligations, right? They might ask you, do I have to make a disclosure in this certain situation? And that is a legal question, right? You can't be providing advice based on the facts what they should do.
Okay. Let me ask you this. Do you believe that if a realtor advises a client that they do not need a lawyer for a closing, could that be considered the practice of law?
I think that could be a major issue. I think that could be a source of liability. And, I don't think realtors should ever be providing that kind of an answer. You should always be saying that legal counsel should be sought to get opinions and to get advice.
So back to what I said earlier at the beginning here is, my advice is stay in your own lane. Don't go outside of those boundaries. Don't go outside of your lane, and do not hesitate to ask questions. Do not hesitate to seek counsel when you're presented with these questions, because you are going to be presented with these questions, and we just want you to do the right thing.
Absolutely. And if you have questions about these obligations, feel free to reach out to an attorney. Feel free to reach out to our legal hotline. And at the end of the day, we just want to make sure that you're not putting yourselves in a bad situation and you're not putting your clients in a bad situation. But keep these general practices in mind, and you should be in a good position to do the right thing.
Thank you, Gabe. Well said.
Thanks, George.